Good afternoon, everyone, and thank you for tuning in. I am proud to present to you today Attorney Carl Habekost, who is the head of our labor and employment practice at Bugbee Conkle, and he is also a certified occupational safety specialist and certified occupational safety manager. Co-presenting today is my favorite safety professional, Donald Elswick of Elsmart Associates, who has more credentials than I can list off, but I will try. CIH, CSP, CHMM, CET, and is currently the Executive Director of Environmental and Industrial Programs at the University of Alabama. And Don also has the benefit of being a retired Navy preventative medicine expert. So Don and Carl have been working tirelessly to keep up on all the latest COVID-19 updates with regard to employment law and workplace safety. And when it comes to this pandemic in the workplace, this is the dream team here to answer all of your questions. So without further ado, Carl and Don.
Thank you, Carrie, and thank you to everyone who are taking time out today to listen to the webinar and take a look at the slides. There is quite a bit of substance on the slides, so you can use them for reference when we're done. And this is a very fluid situation. The problem with this is that it's moving constantly. So what is coronavirus? That's what we're going to talk about. And Professor Elswick, former Professor Elswick, former Navy preventative medicine expert, is going to kick it off and lead us through the presentation at this point. Don?
Sounds great, Carl. And first of all, I hope everyone that is listening, I hope you realize Carl, Carrie, and I are all appreciative of your time today. We hope your family, coworkers, and all the people around you are not only practicing social distancing, but at doing everything to keep themselves healthy, not only physically and mentally. During these times of crisis, remember, it really helps to talk and work with each other. And speaking of that, I just want to go into some details. I know we've been just swamped and really overdosed with information. So if you look at the coronavirus or COVID-19, the novel COVID-19 virus, basically it's the seventh known coronavirus. Once again, the theory, and again, it is not confirmed, so we cannot really say for sure, but the belief is it did jump from potentially a fish to a human, and it spread through the infection from human to human. There are several, and we know that whether it's SARS, whether it's MERS, this is also a coronavirus that is common. We've seen it in common colds. But one of the things we're seeing with this is it's very distinctive too. So as we're going through the properties, I want people, and especially I've cautioned, whether it's in our medical school, talking to the med students, or even talking to employers, a lot of information well intended, as we know, that came out about the flu. And as I say on this slide here, it's very pneumonia-like. However, each of the symptoms on its own does not indicate the presence or absence. This is a time when Carl and I talked about it really takes not only legal counsel, it takes the medical professionals, and also I hope whether you're an HR or even a company owner-operator, that you're working with a team of people. And again, we do know that the symptoms are 2 to 14 days after exposure. We know that the situation, if you've been tracking on CDC, it was declared by the World Health Organization, or WHO, as a global pandemic. Carl is going to talk about what that means to us from an emergency regulation and also even statutes, what's going on. Again, the virus is spread among close contact, so I can't reinforce, and we know that a lot of us are now being asked to work from home, to limit contact, and to protect others. And the last thing, and we'll talk more about a plan as an employer, but Carl and I want to give that best advice that you're hearing from not only medical and health professionals, but hopefully you as a safety or an EHS professional or an HR. If you think you're exposed, talk to your physician. The physicians are well in tune with what to do. They'll also decide whether your signs or symptoms you need to test. And the most important thing, if you've been traveling to known areas of very high contamination or potential infection, make sure that you are seeking out that advice. And the last, we know this, there's no vaccine or specific treatment. There's a lot of experimental things being tried. I think anyone that's followed some of the news conferences, just the scientists and even many people who work in our area of preventive medicine and occupational health, they are just really doing what I call incredible research. So remember, some patients, and we are targeting the very old, is where we're trying to prevent the disease and help them out. But again, you may have friends or relatives that do require hospitalization. But again, start that with your regular physician. Try not to overload the medical. And with that, I know Carl is going to talk more about some of the regulatory requirements, OSHA, the Ohio Workers' Comp, ADA, FMLA, and unemployment. So, Carl, please go over your areas here, and thanks again.
Well, thanks, Don. This looks like a bunch of alphabet stuff going on here. But what we're going to address really is some of the new laws that have been implemented or just signed into law this week. Before we get there, when everyone thinks about occupational health issues, OSHA comes to mind. What we want you to understand is that most of the employees are at a low risk of exposure. But that doesn't mean that you shouldn't follow good hygiene and some of the risk reduction or risk mitigation processes that we're going to talk about here today. The primary exposure for the coronavirus is healthcare industry. But some other industries that you might be surprised would be mortuary services. And hopefully, they won't have a lot of exposure. But with this worldwide pandemic, you need to think that those employees certainly are exposed. Laboratories, airline operations, border patrol. A list that isn't on here would be first responders, police, the people who are out there protecting us on a daily basis are exposed to this virus. Now, OSHA has, when you go to their website, OSHA has information on COVID-19 or the coronavirus. It does not have a specific standard, at least at this point in time, addressing the coronavirus. Employers should always have the health and welfare of their employees at mind, top of mind, first and foremost always. If OSHA is going to address workplace safety dealing with the coronavirus, they're going to address it through what's known as the General Duty Clause, Section 5A of the Occupational Safety and Health Act. That is sort of a catch-all provision. Really what it says is that employers should provide a workplace that is free of recognized hazards. Because there is no specific regulation addressing this particular issue, the General Duty Clause comes into play from a legal standpoint. If you want to know more information, we have provided you with links to the new temporary guidance that was published by OSHA. Don will get into that a little bit later in our presentation. Also, because this is an airborne virus, respiratory protection standard could also come into play. Now, the coronavirus has no legs or motors of its own. It's just a virus. It becomes dangerous when we don't follow regular hygiene practices. We cough, we put our hands to our face, and droplets get into the respiratory system of a human being, and then that's where the problems come about. So following the guidelines that we just mentioned are very important. Center for Disease Control also has a lot of good information. OSHA can assist you as an employer. Like I said, go to the website, also call. They'll provide you some information, but as a general rule, OSHA is not going to be involved with this from a regulatory standpoint. All right, well, what does workers' compensation have to do with this? It's amazing. We've gotten multiple phone calls already from clients asking whether an employee would be able to file a workers' compensation claim and asking whether it would be allowed. The law is going to be very difficult for an employee to prevail in a workers' compensation case. My slide is sort of a little behind what I'm talking. I might have clicked it a little quick. This slide is actually talking about what the workers' compensation system is doing at this moment. The workers' comp program, as far as we're familiar with it, is sort of shut down. Hearings are being held by telephone. Only critical issues in the workers' compensation system in Ohio are going to proceed. That means compensation issues. Injured workers are going to be paid at least through the end of April. And the only issues that will be adjudicated by the Industrial Commission are going to be permanent total disability cases, temporary total issues, wage loss, and allowance issues. Medical examinations at this time, it's kind of difficult to say whether they're going to go forward or not. This is all fluid. And if it sounds like I'm kind of hawing around, I am, because it's a very fluid situation. Some doctors, frankly, are not following through on medical examinations. So we don't know whether exams are particularly going to go forward or not. These are the permanent partial issues. That's not going to be processed by the Industrial Commission or the Bureau. They're not going to proceed with that. The Bureau has suspended some requirements for employees to do things such as job searches. They're going to continue to pay living maintenance compensation, and that's for individuals who are in an authorized rehabilitation program. Normally, there are certain requirements that an individual has to fulfill. They're sort of suspending those requirements. Here's the slide I started out with. Whether or not an individual is going to have the capacity to have an allowed workers' compensation claim. Theoretically, yes. However, we posted here on this slide the requirements for a compensable workers' compensation claim involving COVID-19. There are three elements. The claimant or the injured worker has to establish the disease was contracted in the course of and arising out of employment. Well, now think about that. This is a worldwide pandemic. It's going to be very difficult for an employee to establish, more probable than not, that they contracted COVID-19 in the course of and arising out of employment. And then the other two elements are listed on this slide. And like we said, these slides are a good resource for you after the webinar today. A doctor is going to have to give an opinion on behalf of a claimant that they contracted COVID-19 as a result of work activity. Generally, that's going to be impossible to give a credible opinion from a medical perspective. However, certain professions will have a higher likelihood of that occurring. For example, healthcare workers. You're going into an enclosed space in a doctor's office. They are much more prone and much more likely to be exposed to the coronavirus than the public generally. So enough of that. If you have any other questions, feel free to ask Don or I. Americans with Disabilities Act. And as I move through these different slides from now on, be aware that the coronavirus crisis touches upon every employment law on the books. We didn't bring up the Fair Labor Standards Act in this presentation. That is wage and hour issues, whether somebody's exempt or non-exempt, and if they don't work, do they get paid? That's going down the rabbit hole, as they did in Alice in Wonderland, and we're going to go into a whole different world if we do that. So we're not going to talk about Fair Labor Standards Act right now. I'm sure most of you on this webinar have heard something called the Americans with Disabilities Act. Typically, employers are not allowed to do anything even mild, such as taking an employee's temperature. That is considered to be a medical examination under the terms of the Americans with Disabilities Act. An employer cannot sponsor or require a medical examination for an employee for disability-related issues unless they comply with certain requirements under the Americans with Disabilities Act. We've listed those on this slide. However, because now this is a pandemic, referencing the EEOC, that's the Equal Employment Opportunity Commission's pandemic guidance, employers now are able to take temperatures. And you have heard that for most of this week. This guideline, the pandemic guidance, actually was promulgated in 2007, and I can't remember exactly which virus. That may have been the SARS virus, but this has been on the books now for over a decade. It's definitely something that you should be familiar with. In this instance, though, however, just know that you can take your employee's temperature prior to them engaging in work. The fact that Governor DeWine has publicly said employers should be doing that gives you plenty of protection, and I would have no fear for you receiving any sort of harm under the Americans with Disabilities Act for taking temperature of an employee. But even that said, you're still held to accountability when you get information about an employee's disability. You really are not allowed to disclose the name or any other personally identifying information of the employee who tested positive for the coronavirus. There is one exception. That is what I would call the joint employment relationship. If you're a staffing company or you're a site employer employing a staffing employee, you have to communicate that information. But other than that, you are obligated to keep the information of testing positive of the coronavirus private. Get yourself in trouble if you start talking about someone's disability, your employee's disability. We are practicing social isolation today, so all three of us, Don Elswick, Carrie Ramirez, and myself, are in different places, literally quite far away from each other. Family and Medical Leave Act, we're going to talk about the new law and how the new law has impacted or expanded the Family and Medical Leave Act, otherwise known as the FMLA. But just be aware that if somebody is sick with COVID-19 and they're sick for at least 3 consecutive days, they are going to qualify for FMLA, which provides them with job protection. The Emergency Family Medical Leave Expansion Act, which was signed into law this week and becomes effective April 2nd, 2020, so about 2 weeks away yet. That expanded eligibility for employees. We have some of the information listed on this slide. It applies to employers with fewer than 500 employees and any government employees. Full-time or part-time, doesn't matter. But they do have to be employed for at least 30 days. Reason for the FMLA leave, circumstances where an employee is unable to work or even telework, that's remote work, due to the need to care for a child because the child care has been closed. A lot of child care facilities are closed. All public schools, in fact, all schools, public or private, higher education or elementary education are all closed. That provides a child care crisis for many employees in the workplace. So their job is protected under this new law that just was signed this week. We do have a typo here that I neglected to correct promptly, but here's the way it works. Under this expanded law, the employee is entitled to 12 weeks while they stay home to take care of a child, but they're also going to get paid 10 of the 12 weeks. They won't get paid for the first 10 days, and here's a typical example. Congress hurriedly running through to get a law promulgated. They didn't specifically say 10 work days. We can presume that it's 10 work days. After the first 10 work days, the remaining 10 weeks, employers must pay employees on this leave no less than 2/3 of their usual pay. It is limited to $200 per day, $10,000 in total. Most of the employees then would be entitled to return to their original job or a substantially similar position. There are exceptions, however, to employers, very small businesses with fewer than 25 employees. For whatever reason, healthcare and emergency responders are excluded from this new law. Now, within the same large bill that passed both the House of Representatives and the Senate and was signed by President Trump, there is what I'll call a sister law, the Emergency Paid Sick Leave Act. Some of your employees may fall under both the Expanded Family Medical Leave Act and the Emergency Paid Sick Leave Act. So you may have employees that fit within both of these laws. Once again, this law affects smaller employers with fewer than 500 employees. There are some restrictions. The employee is not able to work due to a quarantine. So perhaps Governor DeWine later today, when he does his news conference, might very well say, I'm issuing a statewide quarantine. Everyone is to remain isolated except for absolutely necessary trips to the grocery store or the doctor's office or something along those lines. That means the employee is not going to be able to go to work. Now, for some of us in an office environment who do knowledge kind of work, we might be able to work remotely. But if you're a production worker at a factory, that's going to be difficult. They may not be able to work, so they're going to qualify under this law. There's some other points that we highlighted here. The employee is actually sick and they're quarantined. They've been advised by a health care provider to self-quarantine. They're caring for a son or a daughter or other child whose school or place of care is closed. Now you might go, wait a minute, we just talked about that. Well, we did, but that was under the Expanded Family Medical Leave Act. So as I said, prefacing this, you're going to have some employees that will qualify under both. The advantage is under the expanded FMLA, they're going to have their job protected. The Emergency Paid Sick Leave Act focuses on paying employees when they can't work. And as we move along on this, Don Elswick will tell you this is, frankly, a very fluid, always changing area. It makes it difficult to keep up on all the changes. So what we talk about today might very well be different next week. Sick pay, full-time employees are entitled to 2 weeks. That's 80 hours of their usual pay. Part-time employees, you kind of work it out based on the number of hours that they typically would work in a 2-week period. There are limits, $511 per day, total of $5,110 if somebody's off for the reasons we just talked about. You cannot, as the employer, require an employee to use any other paid leave. Couple of things that I want to focus while we're talking about this. Retaliation, that is the most active and vibrant area of employment law for the past couple of years. Employers are charged in an ever-increasing manner for retaliation by employees. An employee might say that all I was doing was exercising my right under the law. Maybe I called OSHA and reported an unsafe work situation. Maybe I reported sexual harassment. You name it. Anything to do with an employment relationship that is protected under the law. If an employee exercises their right, you cannot retaliate against them. So be careful. If someone exercises their right under the Paid Sick Leave Act, do not retaliate against them. If an employer, then the last point, fails to pay the required sick leave, that's going to be treated by the government as a violation of the Fair Labor Standards Act. That can be quite expensive because it's not just the money that the employer should have paid the employee, it's also penalties, damages, could be attorney fees involved. It gets to be very expensive. Ohio unemployment was affected by the coronavirus. Governor DeWine discussed this in I believe it was a week ago, in a conference. And the current 1-week waiting period has been waived, so anybody who's entitled to unemployment compensation does not have to serve the initial 1-week waiting period. Essentially, the Ohio Department of Job and Family Services, which manages and operates and implements our unemployment system here in Ohio, has been told to sort of relax things and move it along, process the claims, make it a little easier for someone to qualify for unemployment. You might know, any of you who handle this area, that most it's in the law that in order to collect unemployment, you have to be ready, willing, and able to work, and you have to be actively seeking work. One might wonder if somebody is quarantined, how they're going to fulfill the requirement under the law. Well, like I said, that's relaxed. So people are going to qualify for unemployment. And Congress decided that this is going to get expensive for employers because there is no free lunch in life. despite what you hear from some politicians out there. And when somebody collects unemployment compensation, that affects the employer's tax rate that's paid on payroll. So the federal unemployment tax rate, the FUTA tax, can affect employers, but it also affects the insurance fund for each state. So Ohio having to pay a lot more unemployment claims than it thought it would is more than likely going to get into a critical situation in the account. So the account's going to probably go negative. What the federal government is trying to do is to give money to the states to help them avoid an emergency situation with the state unemployment fund. I know I'm covering a lot of material fast, but you know, we got to do what we have to do to give you some information, and feel free to ask questions when we're done. This tags on to what I talked about earlier, discrimination. The Center for Disease Control, a federal governmental agency who has been very active in this coronavirus crisis, specifically stated that employers should not assume that someone of Asian descent is more likely than not to have COVID-19. Why would we bring this up? Well, because the coronavirus, or COVID-19, appears to have originated in a province in China, and that's where it took off and gained a lot of momentum. So there would be a tendency, perhaps among some employers, to be a little prejudiced against individuals who look like they're from Asia. Well, if you're going to do that as an employer, you're going to get in trouble. Don't do it. Don't assume that someone with Asian descent has the coronavirus. In fact, before I turn this over to Don, I just want to bring up that Italy has now overtaken China with the largest number of coronavirus cases. So that said, I covered a huge amount of material in a short period of time. I'm going to turn this over to Don Elswick. Don?
Yeah, hey, Carl, just wanted to acknowledge we had a couple of attendees send out that they're seeing the same trends we are, where doctors are really trying to injure or reduce the number of injured workers being seen, and they're not able to get the IMEs scheduled. And I think most of us recognize with the surge that's expected in medical care, those services will be reduced. The other thing Carl talked about is, and I'm going to continue the discussion, is with OSHA. I obviously run the OSHA consultation program in Alabama through UA State. And one of the things that a lot of clients have asked me, hey, do I still have to follow OSHA rules? Well, I hope most of you recognize you do. However, there's going to be exceptions that were put out. And Carl talked about the fit testing requirement being relaxed. However, I want to be careful with the general industry and construction people and remind you that relaxation was only for health care. And again, if you get information, make sure it's credible and evidence-based. One of the things Carl and I are dealing with are questions from clients, from just general people asking questions. I know we're going to have a couple of questions at the end, but we'll make this recording available if you want to pass it to any of your co-employees, management, people like that. But the other thing, make sure you're using evidence-based, credible information. And by that, I know it's easy to fall into information, but again, be very careful about just reading something, even if it looks official. We've had a number of people and companies that have called our consultation and asked questions about, is it really a recordable injury if you get COVID-19 at work? Well, we know from the regulations that it is. However, I want to caution people to say, don't suspend what you've always done, the recordability determinations, and also, make sure that when you're applying the rules, a week ago we gave this presentation, we recommended not taking the temperatures. Well, guess what? Now with the pandemic and the direct threat assessment, that advice has changed, but one of the advice that Carl gave you very strongly is protect that information. So with that said, to kind of make it through my information, and Carl, you did have a lot of information, a great job summarizing that. I wanted to say that OSHA has developed a great website. In the materials that were sent to you, not only was something that is not OSHA developed, but it is the Industrial Hygienist Guide to Pandemic Response. And in that, we tried to give you at the beginning of that about a 4-page checklist. And I hope as you look through that, you realize something that we've known for a while in our roles as occupational health, safety providers, HR providers. We need to look at our plan. Well, one of the things this does is talk about not only planning for illnesses, but also planning for cleanup. And again, that tries to go through and give you direction on that. The other thing that I wanted to make sure that you understood in the OSHA 3990 guidance that we sent out, it talks about going through and really looking at your exposures. Well, as you all know, in OSHA 1910-132D, we're required to do a hazard analysis and a hazard assessment of our workplaces. If you're continuing to work, which a lot of companies are, this is a great time to not only build safety culture, but also build that confidence. Allow your employees to take your hazard assessment, encourage the frontline supervisors with your assistance so we don't create a panic to go through and say, what is our hazard assessment right now? Have we changed anything? What's going on? Now, you may need some help with that. As Carl mentioned, you may have employees that want to wear respirators or masks, and you may have a job where you look at it and say, hey, this mask is actually going to create a hazard to our safety, quality, productivity, cost effectiveness, whatever you're doing there. Look at that with the employee and really use what ADA calls, and I call, the great interactive conversation that you look at those. Remember, you can change and adapt your hazard assessment required by OSHA to respond to these very unique and difficult times, and that will also build that relationship you want to. Here's just some general guidelines, and we'll be sending out at the beginning of this presentation. There's a great 4.5-minute video that I've been using to kind of orient people to what do we need to do? What does social distancing mean? What is good hygiene? And again, if you look at the slide, that frequent hand hygiene and that being able to clean up your areas. We've even had people ask about, what do I need to do to clean up those areas? Well, we're very fortunate that the EPA has given us guidance on potential cleaning products, things we want to use. You know, it's not anything really that is going to be earth-shattering, but it's things that will help you with your employees. The coughing, the sneezing adequate, again, this is where the medical people are well ahead of us. Cough and sneeze into your elbows. Don't, do it in your hands. The biggest thing I want to do, and it's something that many people that are trained in occupational health realize, one of the vulnerabilities with not only chemicals, but as we look at things are, the potential for different open orifices like the eye to actually create a pathway and allow the pathogen such as COVID-19 to come in. Just working with people and telling them, hey, don't touch your eyes. Again, your PPE can help with that. Maybe you don't require safety glasses in an area, but now you suddenly say, we've done a hazard assessment. We handle many porous surfaces or non-porous, and we think we want to protect the people by doing that. So again, the social distancing, if you cannot do the recommended distances, talk to your employees about mitigation. Again, that hazard assessment that is the basis for our safety and health will again help us with this pandemic. The other thing too that we need to be honest with, there is a hazard here. And some of the OSHA standards like bloodborne pathogen PPE still apply. And people have asked me, how does bloodborne pathogens apply to, the COVID-19? Well, again, there are those that are very sick. You're going to have actually mucus and other substances that they may actually leave on surfaces. So again, going back to that emergency action plan and knowing how you're going to clean up and how you're going to travel. One of the questions I've received frequently is, can I ask people where they travel to? If they're coming off of long trips. Well, we're about to see that travel really curtailed. But if they have traveled to a CDC high COVID-19 area, as an employer, you have that responsibility to protect employees and make sure that you follow that general duty clause of recognizing a hazard and protecting them. And OSHA gives that guidance in the 3990. The other thing, and I hope this is familiar to everyone on the call, ironically, what I truly believe in and preach are hierarchy of controls. Guess what? With this COVID-19, and when we were looking at the OSHA 3990 publication and, people were trying to decide what to put in it, one of the things we wanted to do was reassure them, guess what? This hazard or this hierarchy of control, the whole elimination, engineering controls, administrative and PPE, try to look at eliminating or, preventing the cases before they occur. We do this as occupational health safety employees. I know that frequently the professionals do that. As HR employees, we all know the greatest way to prevent, different HR-related matters that we don't want to deal with or have to have take, into our culture or company is actually to lecture them. So again, for U.S. workers, we need to take that page 18 to 23 in the OSHA publication 3990 and say, how do I divide my workforce into high, low, and medium? And again, don't get hung up on those titles. Think about what precautions are appropriate and what task and how can I use this hierarchy of control. And really encourage your workers to think along that too. Will you require workers to wear something? Okay, we know that's at the low end, but can we actually eliminate the hazard at the top end? And the other thing that we have questions about is how do we prevent, contact, especially in high-risk areas and workplaces where you may be exposed to COVID-19. Again, OSHA breaks this guidance down into what we said earlier, the hierarchy of controls. If you do nothing else out of the our seminar today, go out and look at those materials that were sent to you. Look at, the pandemic guide checklist for industrial hygienists. Take that look at it, and also, again, I can't recommend enough. I'm not asking you to read the entire OSHA publication 3990, but definitely take page 18 to 23. Look at those guidelines. See if there are practices you can look at implementing in your areas. And again, you guys in Ohio are kind of leading. I've heard a couple people talk about, Ohio Department of Health guidance. Again, there's a lot of great workers that are great professionals at the state level. Again, follow their guidance. Make sure that if you do temperature checks, that you also respect the rights of your employees and not advertise those. Be very careful, as Carl indicated, with the, information that you're acquiring. Try not to store that if you can. Do this actual temperatures, and then do not try to record them unless there's an issue. And then realize that temperature, there may be other contributing factors to that. Encourage your employees to stay away if they have a fever or sick. Even those critical employees, make sure that they understand their healthcare providers, what they're going to do. A couple of attendees have said, hey, we're having trouble with our physicians. We'll call that physician before you have a question. Talk to them about procedures you can use. One of the things that we're doing on consultation now is, telesupport. Think about with telemedicine now, what can the physicians help you with a simple conference call or even meeting, like we're doing, where they can talk to or even look at patients and decide what's going on. And then the last thing, healthcare's providers are just like us. They are overwhelmed. They may have problems and may not be able to provide documentation. So this goes back to one of the cultural things that are very difficult in our field. At this point, we are going to have to really make some assumptions that during these extreme and unusual times that we may not have that documentation now. One of the areas that I wanted to talk about before we really were looking forward is, again, building that culture. What can I do as I'm going forward? Well, part of this health guidance, have your team sit down and actually how they're going to lecture and what they're going to do. And Carl, I'm going to turn this slide back over to you just to kind of have you reinforce with all the policies you went through, how each of these are going through there. So Carl, are you still there?
Well, I am, Don. Thank you very much. This is a great opportunity. And what I've heard over the years is that for every crisis, there is an opportunity. So this is a great opportunity for you to reassess the various policies in your handbook. For example, sick leave policies. Do you also have a remote work policy? What kind of flexible work policy do you have? And with the coronavirus, you're going to have to implement some sort of flexible work policy, sick leave policy. The most important thing, and Don touched on it, that I want to emphasize again, I think I said it early on, if you focus on the health and welfare of your employees, 99% of the time, you're going to navigate the minefield of employment issues without a problem. So you have absolutely no legal liability for asking somebody to do self-assessments, take their own temperature, etc. We now have multiple questions and answers, questions that have come up when we've done this presentation before. Don, you're going to chime in on
some of these. I'll go ahead and take the first one, Carl. And it kind of says, why do OSHA and CDC recommend goggles in addition to the precautions? Again, because of the airborne nature of this, and also even the N95 respirators will be recommended for hazard assessment. One of the areas I know we've heard about is healthcare shortages with N95. We've had clients that have requested, hey, what do? I can't get the N95 respirators. This is one of those opportunities that the crisis will give you where you can actually increase your protection and make those changes you want to do in your program. Start looking at the loose-fitting PAPR. You eliminate and that's the powered air purifying respirator. You eliminate the medical certification. You eliminate fit testing. It's just a great chance. And by the way, you're moving your protection factor from 10 to 25. So again, this was just one question we had. I'll go ahead and hit. I talked about the bloodborne pathogen standards. and universal precautions. Again, even though the universal precautions do not apply to sputum, OSHA has recognized that the following standards do apply, and that's why they're recommending the minimum precaution for the BVP. And again, just another question, bloodborne pathogens. Even though COVID 2019 is a respiratory, it's really going to hit the healthcare. I think Carl and I have talked about there are those potentials, but again, if you're doing your record keeping and doing good recordability analysis, that should not be suspended as you're looking at those. And then the last thing we just talked about, there is an exemption for illnesses of cold and flu. However, OSHA has made it very clear that COVID-19 is a recordable illness, and the exemption under 1904 5B2 Roman numeral 8 is not applicable. So that was our questions going through. And Carl, I'm going to let you take the next one here.
Well, yeah, but it's interesting, Don, on the OSHA recording that you covered on the last slide. I thought maybe a question popped into my head, so I thought I would just ask you. How does an employer know, or even maybe more than 50%, that someone got the coronavirus as a result of work activity? Isn't a recordable incident required to have some relationship to work?
Absolutely. And Carl just hit it again. What we all know and what he's hitting at is this is a time where one of the areas you may want to look at is your investigation into any unwanted incident, but in particular to this. And once you have that documentation, submit it and say, and the default is going to be normally, and I'm very careful saying this, in most workplaces, COVID-19 will not be a recordable. We all know that, but again, I would take the time to do that good investigation and that good recordability determination, just like with the next question, Carl, as far as restricting workers and quarantining them. Do that with data-based analysis. You know, before, if they come in and they have a concern about a family member or they are living with someone, definitely use that information and data to make your decision. Do not make it an emotional. Carl, did that answer it?
Yeah, yes, and I would say at this point also, whenever you're making any of these decisions, as Don said, you have to have some objective basis that does not violate the law. So, for example, if you're going to restrict somebody for coming into work because they're of Asian descent, and perhaps that's, you know, the only real reason you've got, well, then you're going to get into problems with the EEOC. So can you restrict somebody for coming into work if they've traveled somewhere that is known to be a hotbed of the coronavirus, such as Italy? Yes, for the protection of your employee. So, next slide. How does the 2019 outbreak compare to previous coronavirus outbreaks? This one is apparently, by all analysis, more concerning. It's very, very contagious, and it's devastating our economy. So, I mean, I don't think there's any comparison. Don, do you have any comments on this?
Or that's even if you look at the data and the research. I've had several clients, and this is one of those areas right now that I don't have the evidence to do it. If you're looking at trying to use things that you may have used like UV light in that 200 to I think it's about 280 nanometers that normally would do something with flu type outbreaks. We don't know that it is effective against the novel COVID-19 reaction. So please be very careful about standardizing that. Carl, we did have one person that said if an employee or their family member have traveled, do they need to self-quarantine before coming to work? And I'll let you go ahead and answer that from a legal. I will tell you from an health safety perspective, definitely if they believe a family member has been exposed or does have the COVID-19, again, that that quarantine would be applicable from an health standpoint. But go ahead, Carl.
Yeah. Well, it's kind of, you have to use some common sense on this, and it sort of flows from what I said earlier. An employer can operate the business as they see fit, except if they're going to violate the law. Protected classes, age, race, sex, religion, disability, those are protected classes. If you're concerned that a family member exposed one of your workers to the coronavirus, then you have every obligation to protect the other workers at your place of employment and do some investigation, do an analysis, do a hazard analysis, and if your hazard analysis shows that you should have that individual stay away from your employees, work remotely if possible, then you have an obligation to do it, and you're not going to violate the law in that regard.
Great advice, Carl. Treat everybody the same. And in that same tenure, I know Terry has a number of your questions. One of the commitments Carl and I will make to you, we will either post or send out the answers to any questions we don't get to. But Carrie, go ahead and start the questions and try to assign them to Carl and I as you give them. Thank you.
You're welcome. All right, let's see here. Absolutely.
Hey, one that popped up on mine is I have a question regarding compensation. I have a healthcare worker taking care of a patient that does not have a doctor or COVID-19. Later, we found out that the member of the family with the patient was identified as COVID. Would the healthcare worker have a compensatable claim? So in other words, I'll summarize. It sounds like we've got a healthcare worker caring for a patient that had a COVID and they come down with the COVID-19 disease. So go ahead, Carl. Is that compensatable?
Well, it's my understanding that healthcare workers are exempted from this new law, that the new paid sick employee paid law. Now, they would be entitled to protection under the Family Medical Leave Act, the old Family Medical Leave Act, assuming that all other requirements are met, that the employer has a certain number of employees within a 75-mile radius, and the employee worked the requisite number of weeks and hours in the year before. But it's my understanding that healthcare workers are exempted from these paid sick leave laws that were just enacted this week. So I don't think, unfortunately, that individual would be compensated.
So, Carl, you're giving the classic answer, it depends. So great job on that.
Well, I know people don't like that when lawyers say that, but there's so many factors involved in this situation. It's like trying to hit a moving target.
All right, I got another question for you guys. Okay, what does the OSHA guidance require of employers? Is it sufficient for an employer to recommend the current CDC practices for personal hygiene, or should they be mandated?
I'm going to take the way OSHA looks at the general duty clause, and I want to hit this and for all those to think about. The general duty clause says the employer failed to keep the workplace free of a hazard is the first criteria. You did recognize the hazard, and the hazard was causing or was likely to cause, physical harm. and there was a feasible method or useful method to correct the hazard. So my answer to the question is going to be pretty clear what OSHA says. Protect your employees, whether it's COVID-19 or whether it's methyl bad stuff or whatever they're dealing with. And I would encourage you to do that hazard analysis that's required, as we go through our normal operations, if you're general industry, 1910, 132D, and kind of make sure that you're protecting them. So the short answer to that is, yes, I would mandate it, but I'd also talk to the employees and say, are there areas we can't comply? What can I do to help you to comply with that guidance?
And there's a follow-up related question. What specific PPEs does the OSHA guidance require an employer to provide?
The question was what kind of PPE, which is personal protective equipment, are required. And I believe that depends on the job in the industry. But I'll kick it over to you, Don.
Okay, great. Well, if I understood the question correctly, basically your hazard assessment will determine that PPE that you're required to provide employees. If they're talking about, and I've had this question with a voluntary respirator use, let's say you do have someone that needs respirator or that does not need a respirator, which is consistent with, let's say you look at CDC guidelines and things like that. Again, that's where you as the employer need to do that PPE assessment. If you feel that it is not required, then you are not required to pay for PPE. If it's non-specific protective footwear, I always think of that, everyday clothing, some of the skins and creams, things that they normally would need. But the other thing, too, you don't have to, as far as PPE, you will have to provide something that you require in most cases. Now, there are some exceptions to that. So go ahead, Carrie. Next question.
Okay, next question. We have multiple companies under our main company umbrella name. Some companies are under 500 employees. Some are above that threshold. Will the Emergency Family and Medical Leave Expansion Act apply to some of our companies and not others? So this one's for you, Carl.
Yeah, boy, that's an intricate question that I'll give you a very simplified answer. And then if you would like, when we're done today, we can get into the weeds on this. A lot of this depends on how the companies are set up, whether there's common ownership amongst the companies. Most corporations today have an umbrella organization. It reminds me, and I don't want to engage in levity, but sometimes you have to. Kurt Vonnegut wrote a novel called Player Piano many, many, many years ago. And it was based on the fact that the entire world was owned by one giant corporation, but there were just little companies that were part of this one giant corporation. And in my practice, I see with ever increasing frequency that very fact pattern. So let's just say, for example, that the individual who asked the question has 5 different companies, but they're under one umbrella. Well, it depends on how it's set up. If the umbrella organization is there to provide, let's say, payroll activity for the 5 companies, or HR activity for the 5 companies, or safety guidance for the 5 companies, then I believe the individual companies would control. So if one company has 400 employees, then they would fall under the guidelines of the new law. If the company had 600 employees, then it wouldn't fall under the new law. But I'm going to throw another monkey wrench into that. What if the company that has in my example, that has 400 employees, that it also utilizes 150 temporary employees over the course of a year? Would that company be beyond the 500 employee threshold or not? It's a good question. I would say more than likely, the way other areas of the law are, that temporary employees count as employees for qualifications of FMLA and ADA, so why wouldn't it count for this particular situation? So I guess what I'm saying is that it depends on how the company is set up. If it's not very clear, if you have a good argument to make that each company is individual and some companies would not fall under the parameters of this and some would, because this is such a crisis situation and it's so fluid, I think you're fine as long as you have a reasonable interpretation. So there's no black and white answer to that, is what I'm saying. You can make your best judgment. There's nothing in the law or the act that says that you have to combine all the companies together or not.
All right, Carl, I have another question for you regarding the FMLA. Did you say that FMLA does not apply to healthcare staff, for example, HR at a nursing home?
No, I don't think I said that. I think it's healthcare providers, the people who are on the front lines.
None of the regulatory environment have been suspended. Be very careful with the new laws, regulation, especially proposals, that you listen closely.
All right. How does a quarantine apply to manufacturers whose processing equipment cannot be shut down?
And I'm going to this is basically, if you have, and I think most of the regulations, wherever you're doing those, shelter in place, quarantine, whatever you're asking at, as Carl indicated, there are going to be provisions so you can continue to operate your facility safely. So I would definitely, whoever you're working with, again, we're fortunate that the Findlay Hancock Chamber of Commerce sponsored this webinar with Bugbee Conkle. And one of the things I would say, if you have those concerns and those ideas, filter those up through your representatives, and use these bodies in Ohio, whether it's the Manufacturers Association, whether it's your Chamber of Commerce. Definitely make sure of where those are dangerous and where you don't want to. And, that would be my advice. It's all about communications now. Carl and I spent a lot of time talking about it. One team, one fight. We all are now being mobilized, just like during an enemy, and it's been called the invisible enemy. If I can encourage anyone on here, communicate, talk to each other, and we're going to come through this better, but it may be stressful on your fellow workers, and take care of each other. So that's how I would answer that right now, Carrie. Go ahead.
All right. Are you sure you guys want to take that last one? There's a lot more questions. I don't know. There's still about 50 people on.
Well, I'm fine to keep going as long as some of the attendees are still interested in listening. I don't know what Professor Elswick's got going, but you want to go another 5 or 10 minutes, Don?
Go ahead, Terry. You convinced us. What is it?
And I would like to say, that sometimes it's difficult to answer a question when it's coming through a third party like Carrie, because then I don't have the opportunity to have the interactive process and try to clarify certain points that are critical from my point of view. So that's why Don and I both are opening ourselves up on behalf of the Findlay Hancock County Chamber of Commerce, and we'll be more than glad to answer questions individually, more on a one-on-one basis afterwards. That's sort of my limited liability. I'm limiting my liability on this webinar. Okay, Carrie, go ahead. Ask another one.
All right, thanks. When taking employee temperatures as they enter the building, is there a requirement to have that be private from other employees? For example, if there's a line of employees waiting to be screened and temped.
Don, you want to start out on that one?
Absolutely. Again, HIPAA requirements have not been, because of the World Health Organization, their direct threat, which is why we can now even do temperatures. One of the things that is not suspended is the privacy. If you look at the EEOC document, and Carrie, we can make that available, we'll send it out, it clearly outlines protection of employee information is still a requirement. So please do that for not only yourself, but your employers. Again, hopefully most of you recognize, don't make that 100-meter run decision, make that marathon decision. So the answer is absolutely.
Yeah, good answer, Don. From a legal standpoint, that information is protected health information. So you would need to do everything possible to maintain privacy. And then the results of that, if an individual has a temperature that reads at or above 100.4 degrees Fahrenheit, then that is considered to be a temperature that you got to deal with then at that point. So even any information, health information that you might get when you're talking to somebody and you begin to perceive them or they are a disabled individual, you have to protect the privacy of that health information. So as Don said, the ongoing requirements of the ADA, OSHA, they're still going on in the midst of all this crisis. So you still have the obligation to comply with the elements of the law. It's just that now we're adding on some more legal requirements and we're expanding the pre-existing legal requirements. That's all really, if you're going to simplify it, that's all that's going on here. Carrie?
Yep, another one for you, Carl. Rather than actively encourage employees to stay home if they're ill, can an employer require an employee to stay home if they're ill?
Yes, absolutely. Absolutely. There's not, in fact, I believe, and I'm, I don't want to create a cause of action that maybe isn't there, but let's look at it this way. I had a friend of mine who would play devil's advocate and say, well, let's stand it on its head and see what it looks like. If you have an individual who has a temperature and exhibits other symptoms of the coronavirus, and you allow them into the workplace, and they infect people in your workplace, what's your liability? What if you have an employee who has severe asthma? You allowed this sick employee to come into the workplace, infect another employee with severe asthma, and the coronavirus takes off. It now has legs. It entered into the lungs, and that individual becomes very, very sick or perhaps dies. What is your liability as an employer? Let's go back to the general duty clause that Don just talked about. Clearly, the coronavirus is a known hazard. You're required to protect employees and provide a workplace that is free of recognized hazards. So just that one little sliver of the employment environment or the employment laws, you've probably violated. There could be creative plaintiff attorneys out there who would say, gee, good Lord, you knew that this was a risk and you just killed my client. I'm going to file a lawsuit against you. So my answer to that is yes, you require them to stay out of the workplace. Don?
And I want to add to that too with Carl's answer. Again, and I keep referencing back to 3990, the OSHA publication 3990. it really talks on page 7 and 8 how to develop that infectious disease preparedness response plan. And if you as an employee have not developed that and made that clear, so a lot of the legal issues that Carl is talking about can be raised, it's a great way to not only communicate what you're going to require, but if you look at the guidance again on, page 7 and 8 in that plan, it really tells you what the culture you want to improve. And I know I've got students on here, and Professor Varwig's the SOH 420 students and some of the people out of Alabama. And I just want you guys to know this is your role to really go to management and plan this preparedness and response plan. So great answer, Carl. Great question, Carrie.
All right, this is the last one, and then I'm going to let you guys answer the rest of them afterwards because they're a little bit more involved. We have not sent out layoff notices yet for employees. Can they file unemployment prior to receiving something in writing from us? Carl.
Very good question. If anybody can file an unemployment claim at any time. The requirements are that they be unemployed or they be underemployed. If you have not officially laid them off yet, they can certainly go apply, have the claim ready to go. Perhaps that first week that they claim would be denied because they don't meet the requirements. Maybe they're still working, or they have earnings that exceed the average weekly wage in their unemployment claim, but they can go ahead and file I don't know why they would, but they can go ahead and file. The bigger question that Don and I are getting at this point is this: what if the company, due to reduced business that has been caused by this crisis, it goes ahead and lays off some employees? And let's assume that the number of employees don't exceed the requirements under the WARN Act, that's WARN, that would require you to give notice to your employees and give notice to public officials, etc. Let's just assume that you lay off 25 employees. You laid them off before this new law became effective. Now, does the new parameters of the new law, which would be the paid sick leave or the paid FMLA, do any of those laws affect these people who were laid off by your company, somewhat related to the coronavirus, but before these new laws came in effect? Do those employees become an exposure for the company as far as having to pay sick leave and all that? And that's really the unanswered question at this point in time. So, I know I was rambling a little bit, but it brought into light a big issue of companies laying off employees now, but the new laws don't become effective until April 2nd. So the benefits of the new law really cannot be applied retroactively in any normal circumstance. But we're not living in a normal world right now. So,
you guys have any other questions? You see their emails right there on the screen. That's the best way to get a hold of them right now, with a lot of people across the country moving to telework. A lot of the telephone services and meeting services are having issues, so email is actually a little bit more reliable right now.
Mm-hmm. And I would like to say real quick a big thank you to Findlay Hancock County Chamber of Commerce. They're very concerned about members, and they wanted you guys to at least get as much information as you could as of today, March 20th. It might change next week, but Doug Jenkins does a nice job, and we wanted to extend our thanks.